Hi guys, so this is a website and a YouTube channel which is here to help you run your own claim. Now it's not just a small claims help and advice service. I cover everything to do with general litigation, and that means whether or not your claim is allocated to the small claims track, fast track or multi-track. This is also a general litigation support service. But nevertheless, where you're handling your own claim, you'll probably be running a small claim of under 10,000 value. Now that brings me on to what is a small claim and the classic criteria, the current criteria, because don't forget the law changes and the government is often changing the ceiling. The current figure is 10,000. Anything under £10,000 qualifies as a small claim. Okay, now please, the reason I've referred to the CPR Rules, Civil Procedure Rules, Part 27 and Part 26 are the relevant sections. Look below in description boxes for details, is because the law does change, so you do need, and that's the oracle as far as the criteria for small claims are concerned. Okay. Now, as you'll see, if you log in to the CPR Rules, that the criteria are, you can look at them here. The criteria are relatively straightforward, with two key exceptions. That's personal injury and housing disrepair claims. Now, in personal injury, it's 1,000 for pain, suffering and loss of amenity. That part of your claim for the actual compensation for the injury itself must not be more than 1,000, okay? Then if it's under 1,000, it's a small claim. Likewise, housing disrepair, anything under 1,000, any repairs under 1,000, and where any additional costs are also under 1,000 in housing disrepair claims. Those are the two main exceptions. All right, now, when you're looking at this issue, you also need to look at the allocation rules, and that's Part 26. Now, what is allocation? Well, a lot of people don't understand and appreciate this when bringing a small claim, and I often feel myself like a bit of a cracked record because it's such an important issue and so often overlooked. When you bring a claim in the County Court of England and Wales, it's just a claim. It's not a small claim, it's not a fast-track claim, and it ain't a multi-track claim. It's just a claim. You have the pleading stages, where the parties ding dong with their statements of case, particulars of claim, defence, counterclaim, etc. And then you fill in directions questionnaires, which then helps the court, Part 26, decide on what track this claim should be allocated to. All right, so until that point, it's not a small claim. Go and look at other vlogs on this issue, particularly with reference to strikeout applications, where this is a very fundamental point to appreciate. Okay, so the court then allocates it. Now, the wording of Part 26 is the normal track for a claim of under 10,000 is a small claim. That means that there are other criteria, so you should not automatically assume, with a case of personal injury and housing disrepair 1,000, you should not automatically assume that just because of the monetary value, that's the only criteria the court will have reference to it. In most cases it will. Majority of cases it will. Financial remedies, it will. But if you sense that your claim is complex, for example, I had one recently which was an accounting legal finance expert claim of exactly pretty much £10,000, where my opponent actually suggested that this probably belongs in the multi-track because it's going to take 2 days, it's going to require experts, it's going to require a lot of work from the court, from the judge. There's a load of evidence and by way of disclosure, blah, 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 blah. So be careful. Likewise, a claim of 1,500, it might be a fast-track claim. Fast-track is 10,000 to 25,000, multi-track anything above. So just be aware of, that factor. Your claim will probably be a small claim if it's under 10,000 or 1,000 in personal injury and housing disrepair cases. Now, just to conclude and wrap up, I've done a longer vlog which deals with this issue of is a claim always allocated to the small claims if it's under 10,000? Well, no. So go and have a look at that one if you want more information on that issue. That pretty much wraps it up. But I will just conclude and emphasise that the law changes over time, and right now Parliament, I think pretty much as I speak, in February 2018, is considering raising the limits for personal injury claims specifically. Okay, I forget now to what, it's under debate, but it could be 2, could be 5 grand, something of that order. So, but as I say, if you go to the CPR, and if we really want to explore that issue, you can go to the Parliament website and you'll see there's committee meetings about it. But as I say, the Bible on these issues, the Oracle, is the Civil Procedure Rules, Part 26 and Part 27. I talk elsewhere about what a small claim sort of actually is. It goes on to a track where the rules are more relaxed and where lawyers are kept out of the equation, so you don't have to pay extortionate legal fees whether you win or lose. Okay, that's the idea of the small claims track. But in many other ways, a small claim is just the same as any other claim, and it's exactly the same law that applies. So don't think you can do it half-cocked if you've got a small claim. If you need advice and assistance from Redwood Legal, please try and summarise your case in an email, attach documents, and if you've got loads of documents, just the key documents, and then we can quote you the time it's going to take us to give you some advice and assistance. Obviously, our doors are always open for business to conduct your litigation yourself if it's a high-value claim. Thank you for tuning in, and look forward to vlogging at you, with you, to you in the very near future. Bye.